Hello everyone. So I hope you have done good in your UPSC prelims 2020. Now we will discuss the polity section of this examination. So to begin with, let's have a brief overview of it. Unlike previous year, this time the number of questions from polity section is low, it's 8. Clear? But as far as the level of difficulty, it remained the same. Medium and easy questions were there from polity section. So let's begin with polity. So the very first question in set A was this. Pursuant to the report of H.N. Sanyal Committee, the Contempt of Court Act 1971 was passed. So, when it comes to contempt of court, it means that you cannot go against the wills of the court, and on the other hand, fundamental right were there, speech and expression. So repeatedly question is being asked, what constitutes fundamental right of speech and expression and what is contempt of court. So to justify that, to clearly elaborate that, government of India has constituted a committee, H.N. Sanyal Committee, who was Solicitor General at that particular point of time. And on this recommendation of this particular committee, Contempt of Court Act 1971 has been enacted. So this particular statement is correct. The Constitution empowers the Supreme Court and High Court to punish for contempt of themselves. Yes, right. Not only this, the Supreme Court as well as the High Court is also called as Court of Record. Why? Because they have power to punish for contempt. Okay, so in that sense, this particular statement is also right. Third statement, the Constitution of India defines civil contempt and criminal contempt. Clear? So this particular statement is wrong. Civil contempt and criminal contempt is defined under this act, Contempt of Court Act 1971. It is not defined in Constitution. अगर Constitution में होता तो M Lakshmikant में होता. Clear? So this particular statement is wrong. Fourth one, in India, Parliament is vested with the powers to make laws on contempt of court. That is also right under Article 138. So your statement number 1 is right, 2 is right, and 4 is right. So that is what our answer. Right answer is B. You can mark that. Okay. Next question. That is what the explanation which will be provided in the PDF format to you people. Next question is, with reference to India, consider the following statement. Now, this particular question was a tricky one. Why? Because this is not related with the constitution, this is not related with the governance, rather, this is related with the law officers. Okay, so the question reads as government law officers and legal firms are recognized as advocates. Okay, that is an easy part. But corporate lawyers and patent attorneys are excluded from recognition as advocates. So this particular statement is incorrect. Corporate lawyers as well as patent attorneys are also recognized as advocates. So there is a basic difference between lawyers and advocates. And what is the basic difference? When it comes to lawyers, they are those individuals who know about the law, but advocates are those individuals who pleads in court. Clear? So in that sense, a minute difference is there, but this particular statement is wrong. Bar Council of India has the power to lay down the rules related with legal education and recognition of law college. That particular statement is right. So in that sense, answer is B. Okay. Now third question. Third question is related with a constitutional amendment bill. Sorry, yes. A bill amending the constitution requires prior recommendation of the president. So, when studying polity, you might have read about those bills which require prior recommendation of president. For example, a bill under Article 3, a money bill, okay, or a bill which imposes restriction on interstate trade and commerce. So there are certain bills which require prior recommendation of the president, but a constitutional amendment bill doesn't require prior recommendation of the president. So that particular statement is wrong. So if I know this, we have only one option. Clear? That is right. So even if you don't read the next two, you will be able to fetch the right answer, but we'll read the other two as well. When a constitution amendment bill is presented to the President of India, it is obligatory for President to give his assent. No, it is not obligatory. It is mandatory. And why mandatory? Because 25th Constitutional Amendment Act made President bound to sign a constitutional amendment bill when presented to him. Okay. A constitution amendment bill must be passed by both Lok Sabha and the Rajya Sabha by special majority, and there is no provision for joint sitting. So yes, in constitutional amendment bill, there is no provision of joint sitting and it require a special majority. So, बट हमें पहले ही आंसर मिल गया था हमारा पहला स्टेटमेंट पढ़ के ही. बट अगर आप पहले पे श्योर नहीं हो तो आप दोनों और तीन भी देख सकते हो. नेक्स्ट क्वेश्चन, क्वेश्चन नंबर 4, अगेन a tricky one. Why? Because while studying polity, we study about these 4 types of ministers: cabinet ministers, minister of state with independent charge, minister of state, and deputy minister. We do study. Clear? And we divide council of minister in these 4 categories. But this is not mentioned in the constitution. So easy one. Constitution does not provide any such classification among the minister. Constitution only says council of minister. Clear? So this particular statement is incorrect. Second statement, the total number of ministers of the union government, including the prime minister, shall not exceed 15% of the total members in the Lok Sabha. That particular statement is correct. So, maximum strength of Council of Minister is 15% of Lok Sabha. Remember, Lok Sabha, total number, clear? So, this particular statement is correct. Answer is B. Okay. Next, question number 5. Now, this is related with powers of Lok Sabha. Another easy question. Clear? Exclusive power is what being asked. Clear? Means the power, Lok Sabha will have a special power in this particular regard. So, to ratify the declaration of emergency, no, this particular statement is incorrect. The Lok Sabha alone has power to discontinue emergency, national emergency, but when it comes to emergency, when it wants to be imposed, Lok Sabha and Rajya Sabha both is required. Both the bill or a resolution which talks about emergency needs to be approved by both Lok Sabha and Rajya Sabha. Okay. To pass a motion of no confidence against the Council of Ministers, yes, that is exclusive power. A confidence motion as well as a no confidence motion can be brought and passed only in Lok Sabha. So that is what another exclusive power of Lok Sabha. To impeach the President of India. Again, this is not an exclusive power. Both Lok Sabha and Rajya Sabha is required to impeach the President of India, that too by a special majority of 2/3 of total strength of the House. So in that sense, statement 1 is incorrect, statement 3 is incorrect, and your answer is B. Easy one. Next question is question number 6 related with anti-defection law. Clear? So anti-defection law, again 2 statements are there, 1 and 2. Simple questions are there from polity section. It specifies that a nominated legislature cannot join any political party within 6 months. But that is what not the case. Clear? He can join a political party within 6 months, but he cannot join after 6 months. So 6 महीने तक कर सकता है, 6 महीने के बाद नहीं कर सकता. If a person joins, a nominated person joins a political party after 6 months of his or her nomination, then the person will be disqualified under anti-defection law. Clear? The law does not provide any time frame within which the presiding officer has to decide on a defection case. So this particular statement is correct. Clear? It is the prerogative of a speaker, chairman to decide on the anti-defection petition. Clear? So first statement is incorrect, second statement is correct, answer is B. So that is question number 6. Now seventh one, related with Attorney General. Attorney General of India and Solicitor General of India. Remember, in this particular question, UPSC has played with words. Okay, how? Attorney General of India and Solicitor General of India are the only officers of the government who are allowed to participate in the meetings of the parliament. So, when it comes to participation means you can speak, clear, you can sit in the house, not in the visitors gallery. Participating means taking part in the proceedings where you can speak. So that participation in the constitution is provided only to Attorney General, not to the Solicitor General. Clear? Solicitor General can attend the proceedings only when called. जब किसी काम के लिए बुलाया जाएगा, उनसे पूछा जाएगा, then only he can. But Attorney General, being Attorney General of India, is allowed to take whenever he or she wants to. Okay, so in that sense, this particular statement is incorrect. Going to statement number 2, according to the Constitution of India, the Attorney General of India submits his resignation when the government which appointed him resigns. That is not the case. Attorney General may resign when he or she wants to resign, but not mandatorily when the government changes. But generally, this is a convention that if an Attorney General is appointed by the previous government and if the government resigns, as per the convention or as per the moral obligation, Attorney General also resigns. But what is asked in the question? According to the Constitution. So, no, Constitution does not provide this particular provision. Clear? So, that particular statement is also wrong. Right answer is D. Neither 1 nor 2. Moving into the 8th question, it is about the writs. Writs of Indian Constitution. A writ of mandamus will not lie against a private organization unless it is entrusted with a public duty. Now, a writ of mandamus, you have to recall that mandamus can be issued only against a public authority. Okay, it cannot be issued against a private individual or a private entity. But if you go into detail of definition of state under Article 12, any private institution or any individual who works for the government for the purpose on which government works, then it also comes under Article 12. So, if a private entity, it cannot be against private entity, but if a private entity is doing a public duty, then mandamus can be issued against that particular private authority as well. Clear? So that particular statement is correct. Mandamus will not lie against a company, even though it may be a government company. If first point is right, automatically second becomes incorrect. It will be issued against a government company as well. Clear? Any public minded person can be a petitioner to move to court to issue the writ of quo warranto. Now, the writ of quo warranto is a writ which is issued by the court to ascertain whether a person is legally qualified to hold a post or not. For example, if you are having a minister, a member of parliament, whether he or she is legally qualified or not, to ascertain it, any particular individual, not only the aggrieved, but any particular individual can move to court. So that particular statement is also correct. 1 and 3, that will be our answer. That is question number 8. Okay, now this one is the last question, I guess. Ninth one, Deputy Speaker of Lok Sabha. A question is related with Deputy Speaker of Lok Sabha. As per the rules of procedure and conduct of business in Lok Sabha, the election of Deputy Speaker shall be held on such date as the Speaker may fix. So what happens generally after constitution of a new Lok Sabha, pro tem speaker comes, pro tem speaker conducts the election of a speaker, and once a speaker comes, then it is up to the speaker to conduct the election of deputy speaker when and where he or she wants to. Clear? So this particular point is correct. He will decide, speaker will decide. There is a mandatory provision that the election of a candidate as deputy speaker of Lok Sabha shall be from either the principal opposition party or the ruling party. There are two parties only. Clear, there are some independent as well, but it is not a mandatory provision. Anyone who wants to be a deputy speaker can contest the election. It is not mandatory. So this particular statement is incorrect. Moving on to the third one, the deputy speaker has the same powers of the speaker when presiding over the sitting of the house, and no appeal lies against his ruling. So when deputy speaker sits as speaker, he enjoys all the powers and privileges of that of a speaker. So that particular statement is also correct. Fourth one, the well established parliamentary practice regarding the appointment of deputy speaker is that motion is moved by the speaker and duly seconded by the prime minister. Again, this is not a practice. Any person who wants to deputy speaker can contest the election, and any other person in the Lok Sabha can move the resolution that this particular individual wants to. Clear? So that particular statement is also correct. Incorrect, sorry. Statement 1 is correct. Statement 3 is correct. Your answer is A. Okay. So that is how question number 9 is. Now last 10th question. If a particular area is brought under 5th schedule. Now 5th and 6th schedule are those two schedules which deals with scheduled areas. 5th deals with scheduled areas, 6th deals with tribal areas. Clear? And these two areas is being classified in Indian Constitution to protect the tribal population. So, if an area is declared as scheduled area, then what happens? This would prevent the transfer of land of tribal people to non-tribal people. That is what being reflected if an area is brought into 5th schedule. Okay, so that is what answer is A. Okay, so these are 10 questions which comes from polity in this particular year. Previously it was 16, 17 questions, sometimes 21. This time only 10 questions were there. But the level of difficulty of polity questions were same. पहले भी इजी आते थे, इजी या मीडियम क्वेश्चन आते थे, एक दो बाउंसर क्वेश्चन होते थे या डिफिकल्ट क्वेश्चन होते थे. इस बार भी उसी तरह का पैटर्न यूपीएससी ने फॉलो किया है. बट ओवरऑल इफ यू लुक इनटू द क्वेश्चन पेपर by including science and tech, history, economics, the question paper was a bit on the tougher side. Clear? So, as per our expectation, the cutoff will be more or less similar to that of last year. That is, last year it was 87 something. It will be the same this year as well, 87, 88. Okay. So that's all from the polity section.